Well, good evening, everyone, and thank you for joining us tonight for yet another My Pensacola Credit Union free legal webinar brought to you by Staples, Elias and Associates, as well as Mr. Tommy Staples, who will be our presenter this evening. The topic that we will be covering is Florida family law issues and injunctions. Just a few housekeeping matters before we kick things off with Mr. Staples. This is being recorded. We recently launched this series that we're going to try to do about once a quarter here in 2023 and hopefully carry it forward in 2024. We recently did our first one in March. That was recorded. Any sort of Q&A that maybe got a little into personal information or just a little bit more of a dialogue, we cut off in editing. So you can rest assured that anything we do tonight and anything in conversation, if we will be editing it so that it is allowed to be viewed by all our members or anyone in our community that maybe gets the link shared to them and it goes to our YouTube page as well as on our website. So no worries, there won't be any identity provided or again, any sensitive information put out there once this recording is edited to the public. Everybody should be muted and cameras off. That's intentional, just so we keep things organized here as Mr. Staples goes through the information. But as you received in the invite, we will have an open Q&A session towards the end. I will be monitoring the chat feature, and the way you find the chat, if you're not familiar with Zoom, you just hover over the screen that you have in front of you and some controls should pop up. And you should see, if you don't see a chat feature right away, there might be 3 dots that say more. And if you click on that little button that has the 3 dots and more, you'll see chat. You just click on that and you're able to enter your questions, thoughts, what have you, into the chat session. Like I mentioned, I will be monitoring that. If Mr. Staples pauses at any time and asks if there's any questions, you can put those in the chat. Otherwise, you can set them up for when we have the Q&A part or wait to enter them at the end. We are scheduled to be out of here by 8 o'clock tonight. We will be respectful of the time. Should we end earlier, you get a little more time back in your evening. But again, we will be respectful to end and say goodnight to everybody by 8 o'clock at the latest. I believe that's everything I wanted to cover. So without further ado, Mr. Tommy Staples, please take it away.
Thank you very much. Thank you all for taking time out of your day and joining us tonight, or this evening, I guess. I'm not going to tell you too much about our law firm and all of our credentials and the wonderful things we've done and everything. If y'all care to know that, please go to our website, and you're welcome to give me a call, tell you some of that stuff later. But I think everyone's here to learn about family law issues and injunctions. So let's get started. So this is a seminar today about Florida family law issues and injunctions. And the topics that we're going to discuss are going to be a paternity action versus a dissolution of marriage, or what is in Florida known as a divorce, time sharing, which was formerly thought of as custody, but now they call it time sharing, child support, and then we're going to talk about injunctions, which are also known as restraining orders. So let's get started. Now, a paternity action. A paternity action is what you do if you have a child with someone that you were never married to. It is how you establish your rights and responsibilities to your child, but it also establishes your who pays for what, child support and everything else. But that's how you do it in a paternity action. If you are married, but the difference between a paternity action and a dissolution of marriage is because a paternity action, you're only dealing with just children and the rights and responsibilities of the parents towards the children. Who gets the child on what day, at what time, and who transports them, who pays for the cost of transportation, which parent meaning, stuff like that. A dissolution of marriage, you're going to determine your rights and responsibilities to the child, but you're also going to divide up the property, the assets, meaning the things that you've acquired, and the liabilities, meaning the stuff that you owe on. So you'll determine who gets the vehicles and the house, and if you're going to sell the house, who gets what portion of what, right? So the difference in the two, obviously, is that they're very similar. It's just you're not dividing up property with a paternity action because you were never married to acquire any assets and property. Now, a lot of times people come to my office and they say, well, if the Department of Revenue issued, child support, so I've already got my rights established. That does not establish your rights. That only says you are in fact the father, so you're the one that's going to start paying. It establishes your requirement to pay child support. And it's only regarding child support. Department of Revenue does not establish your rights. It only establishes that you are responsible for paying child support. In order to establish your rights in Florida to your child, meaning when do you get to see your kid, on what day, at what time, and for how long, you must do a paternity action. While a Department of Revenue case may have been started, you still have to do a paternity action in order to establish your rights. So a lot of times, people want to know what's the effect of having your name on the birth certificate. And that's very significant. But let's start with what happens if your name is not on a birth certificate. And let's say you take a child, take your son, and go back to Alabama or something. If your name is not on the birth certificate, that's a pretty serious issue. It's actually a felony in Florida. It's interference with custody of a parent, because your name's not on the birth certificate, and it's a criminal charge. But if your name is on the birth certificate, then you have the ability to take your child wherever you want, even if the other parent isn't in agreement with it. As long as your name's on the birth certificate, you can do it. So there is, some danger in putting people's names on the birth certificate, because it does give them some authority. And just because your name is on a birth certificate, does that mean automatically that you're the parent? No, in Florida, there is a presumption that if your name is on a birth certificate, that you are the parent of that child, but it's not. It can be overcome with DNA. And so it's not like just because your name's on the birth certificate, you're definitely the father. No, you still have to go through the paternity action. And if your name's on the birth certificate, or if it's not on the birth certificate, the mother would have to agree, well, no, he is the parent, or no, he's not. And if they say, no, you're not the parent, you can still do DNA and have a DNA test and prove it regardless. So having your name on the birth certificate can be pretty significant. Now, let's talk about alimony. So in a dissolution of marriage, that's a divorce in Florida, you're going to determine a lot of things. You're going to determine alimony, the separation of property, all that stuff, the time sharing with a child, what child support is going to be paid, what, if any, alimony is going to be paid, right? So alimony, this is only going to really apply to married couples if you are married. And really the basis for it is, it's really three factors that come into play. It's number one is the need of that spouse to receive alimony. If they don't have a need, then there's no reason to give them alimony. But the next factor is the other party's ability to pay. While you may need someone to, give you $5,000 a month in alimony because you're used to living a very good life, but if the other party doesn't have $5,000 a month to give you, then you're not going to be able to get what they don't have, right? But the last factor is also the length of the marriage. The longer the marriage, the more likely you're going to get some form of alimony. So again, the factors are the need of one party, the ability to pay of the other party, and lastly, how long was the marriage? So there are three different types of marriage under Florida law. And the first one is if it's a short-term marriage, Florida defines that as less than 7 years. The second one is a moderate, and that's between 7 and 17 years. And lastly is long-term, which is 17 years and beyond. So there are several different types of alimony. There's temporary, which temporary alimony is really used during the course of the divorce. So when you're separating, if one person was a stay-at-home parent, then they're going to be getting some alimony. They need money to live on, right? So you can't just freeze them out. A judge will typically grant that, but most people do that without a hearing, and usually it's unnecessary unless the other party's being a little difficult. But while there are many different types of alimony, the ones that you really see, permanent alimony is really going to apply for just long-term marriages. But again, factors come into play, which we'll talk about in a minute. When you're looking at moderate and short-term, it's rare that you get permanent alimony for those, quite frankly, unless there's some special circumstance, that one party's gets injured and they're not able to work or something like that. Maybe I've just never seen it, quite frankly. Typically, what you'll find most courts typically just take and divide the marriage in half and give that kind of that amount of rehabilitative alimony or something like that. If it's a short-term marriage, maybe you'll get a year or two, something like that, maybe more, but it depends on what it would take to get you back. But that's kind of typically the way that you see it. The factors that come into determining what type of alimony it's going to be is, number one, the standard of living. If someone is, there's a long-term marriage and someone, your spouse is not going to go from having caviar to going to eating peanut butter. They're still going to be able to eat caviar, assuming that you're still able to afford to do so. The duration of the marriage, that's the longer the marriage, the more likely you're going to have alimony. And if it's long enough, then you're probably going to have permanent alimony. But it's not like you can just say it's always this way. There's, if it's 17 years or 20-year marriage, you're always going to get alimony. You still have to factor in, does the person even really need it? I mean, if they're making a lot of money and they one party has the ability to go back and be a brain surgeon, well, if you just have to go start working again and making a bunch of money, then why would you need it? You might need money to be able to get your licensing back so you can become that brain surgeon again if you've had anything lapse. But there are a lot of different things that go into play. One of the bigger ones that I've seen, at least, is the age and physical or emotional condition of the parties. So if you were, maybe married for 15 years, but one party is, 80 years old, most likely a judge or a court is not going to want an 80-year-old to go back and start working. They're probably not going to want to do that unless, there's special circumstances. And obviously the financial resources and the earning capacities of each party. Are you able to go and earn stuff? What would we need to get you to where you can earn things? Or if you never, you don't have any degrees, you don't have any specialties, then, what would it take to get you there? What things could we do to get you back on your feet to where you can earn your own living as well? So there's no real one set, it's always this way. It's really a case by case analysis that courts really do. While you'll ask for, all the different types of alimony, generally the ones you're looking at and the ones that really apply might be, lump sum or permanent periodic alimony or rehabilitative, or maybe even bridge the gap. And temporary is, of course, during the course of the marriage. Now, next, when it comes to divorces and even for paternity actions, remember, paternity is only dealing with just time sharing with children. Right? Time sharing, what was formerly known as custody of children, is what's determined in paternity actions and in divorce hearings, in dissolution of marriages with minor children is what they call it. And the standard for determining for a court to decide who gets the child on what day and how much time one parent gets with the child versus the other is what is in the best interest of the minor child. So a lot of times, people want to know, well, is my child would rather live with me? That might be one factor, and it is one of the factors. The factors that actually apply is, as we have here, Florida Statute 61.13 sub 3 A through T. And there's a bunch of different factors. One of the ones that, where the child wishes to live really isn't a big one. Courts really don't want children to testify if they don't have to. They don't want to put a child in the middle of it, because that would be really, that could be traumatizing to children. And I've done it, but it's something that I've done it several times, but it's got to be pretty necessary for a court to do it. And in order to have a child testify, you have to file a motion for, requesting them to testify. And typically what a judge is going to do is just say, I'm going to determine my ruling as to whether they'll testify or not at the final hearing. Which I've had happen as well. So, again, the court's going to look at the best interest of the child. So, let's say that a child wishes to live with dad. Well, how are their grades with dad? It's, look, your homework is never done according to the teacher that testified. You're never, you look like you're dirty when you're staying at dad's house. You don't have your lunch packed. You're usually late to school, things like that. it sounds like you do want to live with your dad, but he doesn't really have a lot of rules. So it's probably not in your best interest to do that at this point. So those are the things that the court's really going to look at. But when it comes to the Florida statutes, while the Florida statute, the factors, 61.13 sub 3A through T, each factor is supposed to be given the same amount of weight. But in my experience, there are some that kind of tend to be a little more important a lot of times. And some of those are really, where they're acts of domestic violence. That's going to be concerning to a judge. And I think it should be, honestly. If one person's, got a violent history, maybe they wouldn't be the best to have the child as much. Another is the geographic viability. A court is not going to make a child go to school half the time in Alabama and half the time in Florida. They're just not going to do that. For example, if one party moves, an hour away from, downtown Pensacola, and the other party, the marital home, was in downtown Pensacola, a court's probably not going to make a child wake up at 5 o'clock in the morning to get to school because one party moved so far away. So, it's really, there's a lot of common sense that applies to it, quite frankly. But the other one that you see a lot is one parent putting the child before themselves, or are they not? So if one parent really is just trying to use the child to get back at the other parent, and it's clear from the facts, that's something that really aggravates courts oftentimes. So those are kind of the bigger ones, but there's a laundry list of different factors, and it's just, but a lot of it's common sense. Who's just because one parent always drops the child off at school, well, maybe the other parent was the main breadwinner, so they worked a lot more. And the other one, the parent that was at the doctor's appointments, was more of a stay-at-home parent, whether they were a husband or wife. So it makes sense that they would have been more involved in that stuff. But after the parties are separating, who's really doing it? I mean, if you're never really involved, maybe you really, don't deserve to have as much time. That's things that courts are always looking at. Now, when it comes to determining who's going to get how much time with the child and all that, let's talk about the law versus the reality. The law is that each child has, the court wants each child to have frequent and continuing contact with both parents. But under Florida law, there's no presumption for any specific amount of time schedule, unless there's exception in the statute exists, such as there's been criminal convictions or something like that, right? That's what the law is. Now, let me tell you what the reality is. The reality that you see is basically, so under the law, both parents start at 0, and you got to produce evidence basically as to why you should get any time sharing, right? In reality, what you see is both parents kind of start with 50-50, and you've got to give evidence as to why you should get more than 50-50 and the other party should get less than 50-50. A lot of it, again, is commonsensical. So when you're, I've had clients, right? One gentleman that worked on an offshore boat where he was working, for an oil company, and he worked 28 days on and he was off for 12 days, 28 days on and he was off for 12 days. The problem is that it was a 1-day drive to get to where he had to go for work it was way up in New Orleans, in Louisiana. So a court's not going to give you those 28 days that you're not even in Florida. You're not even on land, honestly. I mean, you can ask for it, but they're just not going to do that because you're not even here to do it. If you work nights, a court is not going to make a child wake up at 2 o'clock in the morning because you got done with your bartending job. They're probably not going to do that. If you're working nights, you're probably not getting time sharing on those nights, is really how it works. Now, when we talk about the reality of it, is both parents kind of start with 50-50. That doesn't mean that that's where it stays. I've had it go both ways. My clients gotten more or gotten less, depending on what the facts were. But when you end up really, when you look at child support is another thing that we should talk about. Child support is based on two things. It's based on, number one, your net income, and number two, your amount of overnights. The more overnights you get, the less child support you pay. But if the child, now overnight literally means overnight. You can spend all day with the child, but if the child does not spend the night with you, it does not count as your overnight. Now, in order for you to have any benefit, to have any difference, and I guess I will be getting to this here in a little bit. I guess I'm skipping around a little bit. I apologize. Let's talk about grandparents' rights next. Grandparents' rights. They don't have any rights in Florida. Grandparents don't have any rights at all, period. But courts want you to end up, involving grandparents if you can. So again, remember, what's in the best interest of the child? Are you, ignoring your family? Well, maybe that's something that a judge could consider. I mean, this child was so close with this one grandparent, and then now they were ripped away from them. And, one parent was not acting in the child's best interest. They were acting out of their own anger. As I said, that one factor. So that's kind of the stuff that comes into play. Now, let me ask you this. Can you modify a parenting plan? Absolutely. You can always modify a parenting plan. All the time, you can always modify it. However, the standard is that there is an unanticipated change that is substantial and material. And the same factors apply. Florida Statute 61.13 sub A through T. Those are the factors in determining originally what time sharing schedule the court's going to determine. And if there's ever a modification, they use the exact same factors in determining if there's a modification that's necessary. Is there a substantial change that's material and unanticipated, right? Now, and I'm sorry for skipping around, but here's our next slide, child support. Now, it's based, like I said, on two things, your overnights and your net income. So now your gross income is not your net income. Your gross income is, so if you make $100,000, or let's say you make $40,000 a year, right? Your gross income, if you take 40,000 and divide it by 12 months, I think it's $3,333.33 or something like that, I believe. Well, that's what that's your gross, but that's not what you actually receive after you pay your taxes and all that. Your net income is what the court is looking at. And really what that is what is it that actually hits your bank account if you didn't get $1 back on a tax return, and you also didn't owe the government $1 either? That's kind of where they're looking at for your net income. And so that's kind of what they want to look at. So once you get someone's net income, and generally people, you have to fill out a financial affidavit for a dissolution of marriage or for a paternity action, right? And that's what the court is determining, is using to calculate child support. It's set out there. There's child support guidelines, but it's pretty well set out in the statute, and it's pretty much black and white. Now, one thing about child support is a right of the child. It is not a right of the parent. So one parent can't waive child support. They can't do it because it's not their right to waive. So a lot of times, my child's mother or father said that if I let them have Christmas this year, then they won't make me pay child support this month. If they ever bring it up later in a motion for contempt because you didn't pay child support, or for a modification stating that you didn't pay child support, a court's going to enforce that. Now, a court's also going to probably be upset because, you're not being sincere with me, because you're saying that, they didn't pay you, and you're saying that they were so nasty to you by not paying you, but they also have text messages here where you told them you didn't want them to pay. So while I do have to actually order child support, you're not being as honest with me as you otherwise would, and that's going to go to your credibility and things. So that's kind of how that works. So now, while you have to determine the person's net income, right? And most people lie on their financial affidavit, so that's what you really have to go through. But what is a court going to, now a court's never going to look at it, but whenever you file for a dissolution of marriage or a paternity action, you have to do what is known as mandatory disclosure. And that's things of, you have to produce all the documents in order to support your claim of what you make on your financial affidavit, so that the other party can look through it. But, and both parties have to do this, right? And you can request people to produce more, information or other things as you go along. But as a basis, the Florida statutes or the Florida law requires you to provide mandatory disclosure. So you got to produce some pay stubs and tax returns and or W-2s, things of that nature, bank accounts, credit card statements, bank records, things of that nature. But both parties have to do this. Now, you can also waive mandatory disclosure, but it's like I tell clients, look, I can only be as effective as the information that I'm aware of. So if y'all want to waive mandatory disclosure, I'm totally fine with that. I will do whatever it is that you'd like to do. However, if this person has a bunch of money in the bank and you're not sure, you didn't realize that they were making what they really are making, I will never be able to get that for you because I'm not aware of it. But that's also that's very rare. Generally, parties are relatively aware, or hey, we need to get it because I have no clue what this person makes. We have completely separate bank accounts and records. So it's rare that people want to waive mandatory disclosure and have no clue what the other party's making. So when it comes to child support, though, like I said, it matters about the amount of overnights you get. The more overnights you get, the less child support you pay. But there's a catch. You must have a certain number, and it's 20% of overnights, which equates to about 73 overnights per year. If you don't have at least 73 overnights per year, then you are going to be known as what is called grossing up. And that's what the Department of Revenue does. They always gross up the party that they're trying to have pay child support because they haven't established their rights. And what that means is if you end up going from 1 overnight a year to 30 overnights per year, you pay the exact same child support. However, once you hit the magic number of 73 overnights, that's when it can make a difference. So if you go from 100 overnights to 150 overnights, that's going to be significant depending on how much your net income is and the net income of the other party. That could be a very big difference. It could be hundreds of dollars per month that child support would go down because you have more overnights. But again, you have to just run the numbers in the child support guidelines. The program that we always use and I think just about everyone uses it, is Divorce Power Analyzer, or DPA, and it calculates taxes and everything, and it's pretty dadgum accurate. But you can also run them by hand. There are things that you can get from the clerk where you can run them, I believe, but it's also set out in Florida statutes as well. So next we have injunctions, or restraining orders is also what I believe they are called. Now, what is an injunction and a restraining order? Well, let's start off with what are the parties. The person seeking to get an injunction or a restraining order is known as the petitioner. A person who is the defendant in an injunction proceeding is known as the respondent. So the petitioner is trying to get one, and the respondent is is the defendant on it. Now, the burden of proof. The burden of proof is on the petitioner, okay? The petitioner must prove why they need the injunction, right? And the burden of proof is by a preponderance of the evidence. It's just more likely than not that you need a restraining order, right? So there are many different types of restraining orders. The ones you typically see are domestic violence related, or repeat violence, or stalking. It's rare that you see any of the other ones, sexual violence and things of that nature. Domestic violence, and whenever you fill one out, okay, whenever you fill out a petition for an injunction, the clerk cannot charge you a fee. They're not allowed to by Florida law. However, you have to make sure that you fill it out correctly. Not that you're not going to know what names are there or whatever, but if you don't qualify for that certain type of injunction, even if facts would allow you to get an injunction under another type of injunction petition, you're not going to get it. So for example, what I mean by that is, in order to have a domestic violence injunction, you must be related by blood or marriage to the person that you are trying to get one against, or you resided together as a family, or you have a child in common. So if I say that I want to if I file for a domestic violence injunction against my neighbor for coming over and constantly, harassing me and stalking me and all this other stuff. Well, I was never married to them, and we don't live in a house together, and we've never had children together. So a judge cannot grant the injunction, although it would be granted under a different type of injunction, right? So the standard for a domestic violence injunction is that you must either have been a victim of domestic violence or have reasonable cause to believe you're in imminent danger of becoming a victim of domestic violence. Now, here's the thing, the statute's kind of changed on this, or maybe it's just more clear, but you must have one act that has taken place within the last 6 months. So if you say that, my husband hit me 10 years ago and now I'm afraid of him, and y'all happen to be going through a divorce, it's just so far in time, it's not reasonable to believe that you're in fear, is basically what the courts believe. So there must be an incident that has taken place within the last 6 months. Now, for an injunction for repeat violence, let's say that you have a domestic violence, but you have a domestic violence injunction, but you accidentally filed it under repeat violence, but there's only been one incidence of violence. Well, a court can't actually grant an injunction for repeat violence because there's only been one incidence. So you should have filed it under domestic violence related because of y'all's family relationship, but you can't file it as repeat violence because you only had one incident. So under repeat violence, there must be at least 2 acts of violence from 2 separate incidences. However, one or like stalking or violence from at least 2 separate instances. However, one must have occurred within the last 6 months. You do not have to be living together, and even if you never dated. So this is kind of for like the neighbor issue or coworkers, things of that nature, right? Now, stalking. This occurs when a person willfully, maliciously, and repeatedly follows, harasses, or cyberstalks another person. For harassment, this is whenever you're trying to seek one for harassment, or if a person follows you with no legitimate purpose over a period of time that it causes emotional distress. That's the standard under the Florida statute that applies to that. Now, those are the ones that you typically see, is domestic violence, repeat violence, and stalking, okay? I've never really seen a sexual violence injunction. I'm in injunction court relatively frequently, but I've never really seen a sexual violence. And quite frankly, I have the law on it, but under the statute, it's used for an injunction is used in order to meet the criteria. The violence must have been reported to law enforcement, and you are cooperating with the criminal proceeding, or the offender was sentenced to prison and the term has expired or is expiring within 90 days, and any one of the following has occurred. Number 1, any forcible felony wherein a sexual act is attempted or committed. 2, a sexual battery has occurred. Or 3, luring or enticing a child. Or 4, lewd or lascivious act committed in the presence of or upon a person younger than 16 years old. Or 5, sexual performance by a child. I've never really seen that, but quite frankly, in practice, generally, if any of that stuff has happened, the offender is going to be in county jail anyway, waiting to be, for what's going on with their criminal case. And if they happen to not be and if the case is still pending, then a condition of their bond is always going to be stay away from the victim. And if they don't stay away from the victim, then the court is most likely going to revoke their bond and keep them in custody in the county jail until their criminal case is over. So that's probably why you don't see it. I've just never seen an injunction for sexual violence. Not that they don't happen. I've just never seen one. Dating violence, again, I've never seen that as well. And exploitation of a vulnerable adult. That's kind of a newer one. I think it just kind of started, but I've never seen that as well, quite frankly. So when it comes to how to start an injunction, you must file a petition for whatever type of injunction, petition for domestic violence injunction, petition for a repeat violence injunction, things of that nature. And you must make sure, as I said, that you file it correctly, because if you file it under repeat, but you only have one incident, then the court can't grant it for you because you don't have at least 2 incidences, which is required by repeat violence. Now, how long does an injunction last? An injunction lasts, it can last, it's up to the judge. The judge will determine at the end of the hearing, but they can be forever. They can be for a year, for 6 months, for whatever it may be, right? But in your, it's completely up to the court as to how long they last. They can last anywhere from not having one granted at all to forever and the rest of the end of time, right? So here's the thing. One thing you need to know is about a temporary restraining order. Whenever you file a petition, you have the ability to request the court to grant you a temporary injunction, which would be in place until the hearing can take place and the judge can make a finding of fact, right? So the temporary restraining order just gets you to the final hearing where the judge is going to make a determination if they're going to grant it or not grant it, and if they're going to grant it, for how long. And just because you're granted a temporary restraining order doesn't mean that you're automatically going to win. You could have a temporary restraining order but still lose, right? And not have a restraining order granted forever. Now, can they be amended? Most certainly they can be amended. You'd have to file the proper motion to terminate the injunction or to modify the injunction or whatever it is that you're trying to do. A hearing would have to be set, and the judge would have to make a finding of fact after the evidence was presented as to why does it need to be modified. So I was actually in court a while ago, and there was a gentleman that the victim moved to like California, so he filed for a motion to modify it, and the court granted it because there's not a likelihood that this person is going to end up having any domestic violence issues in Florida because you're now 1,000 miles away. So they can most certainly be amended or changed. Just because a court grants a permanent injunction doesn't mean that they can't later go back upon a proper motion and change that. Now, here's the one thing that a lot of people want to know is who's controlled by it. Just because one party has an injunction, the other party has absolutely they can still talk to you. You just can't talk to them. So if the petitioner is granted a permanent injunction on January 1st, 2023, and sends a text to the respondent on January 6th, 2023, to see if they want to get back together, is the petitioner in trouble? The answer is absolutely not, because the court order only requires the respondent or the defendant in the case not to contact the petitioner. It does not prevent the petitioner from contacting the respondent or the defendant in the case. However, that's also something that courts are looking at as to, is it something they want to modify later, or is there a basis to do this? So a lot of times what you'll see is, if there's a divorce and people are trying to, one party is trying to control the other with an injunction, which does happen, not often, but it does happen. And, let's say they have a temporary restraining order granted because they say the person hit them or hurt them or whatever it may be, and a judge grants a temporary restraining order until a hearing can be done. But between that time, they're texting, seeing if they want to, hang out, and what are you doing? Can you chat? Courts don't look very good at that. I mean, that shows that you're not really in fear. Your fear is not reasonable because you're trying to hang back out with this person. So, that's going to be something that you will probably lose the final hearing because of stuff like that. So again, it's very important that you realize who is controlled by it. And that's a lot of the law on all of it. I know that if y'all have any further questions, I'd love to have all your questions. And here is our contact information. My name is Tommy Staples. I'm an associate attorney at Staples Ellis plus Associates PA. And my personal email address is tstaples@staplesellislaw.com. Our office number is 850-432-4143. And my personal cell phone number, and yes, I do personally answer my phone, is 850-384-3699. So are there any questions?
Thank you, first of all, Tommy, Mr.
Yes,
Staples,
ma'am.
wealth of information, very much interesting and appreciate all your time and wonderful information and insight into very serious topics, of course. And many people out there are concerned about these and unfortunately going through these situations. So it's nice to be able to be educated to a certain extent and then obviously work with professionals such as yourself and your law firm for any help they may seek. I'm
Yes,
going to
ma'am.
actually stop the recording at this time and allow for the Q&A session.